So welcome to CPD4Me. We provide practical and relevant training for busy professionals. My name is Bronwyn Pott, and today we've got a substantive law update. We work in a pretty fast-moving and changing environment, and that includes the laws that we work within. Our aim is to bring you recent case studies, precedents, as well as updates so that you're able to stay on top of your game.
Now, I'm going to talk today about a topic that I think needs a bit of fighting for in the employment space. See, when we're talking about employment law these days, we're talking about an environment where there are about 5 or 6 quite major pieces of legislation which have something to say about the employment relationship. What happens sort of pre-contract? What can arise there? Well, there's a couple of cases where, in fact, the contract and what has been said around the contract has led to employers having to pay out quite a significant amount of money to candidates, and in one case an employee, arising from what was said before the contract was even formed. But under the Building and Construction Award, there are a number of allowances that are payable. Site allowances, industry allowances. And of course, the allowance that gets a lot of employers into difficulty is the daily rate travel allowance. It's a clause within that award which goes into quite some detail as to the circumstances, but in essence, in many occasions, there'll be an entitlement for employees who are operating within a 50-kilometre radius to be paid an amount, and it's a little over $17 an hour every day that they travel to and from a building site. So the question is, if someone is paying them an hourly rate well above the award, should that subsume that allowance? And there have been a series of cases on this. I'll give you the cautious approach. And the cautious approach is to include what we call a Re and Redano clause. A very common question that I encounter as an employment lawyer relates to the issue of probationary periods. Now, a probationary period stems out of employment contracts, but has now become a part of the employment landscape for virtually all employees. But its significance particularly pertains to the question of a worker's right to unfair dismissal. Because one of the requirements to be entitled to make a claim for unfair dismissal is that you have worked the minimum employment period. The minimum employment period is set out in the Fair Work Act. Some employers get themselves into a little bit of difficulty in relation to policies and procedures when they might have a clause in there which says something like policies and procedures are not part of the contract and don't form part of its terms, etc. But elsewhere in the contract, they might, for example, they might have a section on disciplinary, and they might have a clause in there which essentially says that all disciplinary matters will be dealt with in accordance with the disciplinary policy. Now, even though there's that sort of general statement elsewhere, the courts will jump on that and they'll say, okay, if you've got this clause over here, we will take that as a specific case. So I have just run through 9 different ways in which the employment contract still is worth considering and applying in particular circumstances. There are a lot of other instruments in town which have a lot to say about the employment relationship. But many of the issues around senior employees, whether they're acting for the employee or the employer, stem from either party not paying attention to the contract at the point they started the employment and everything seemed shiny and new.
I hope you enjoyed this session today from CPD4Me. Continuing professional development should be about learning new things, about challenging yourself to learn and grow, about finding better ways to do the things that you do every day.